My dear students, today we will learn what is doctrine of compensatory discrimination with reference to our Constitution of India, especially with reference to fundamental right of equality, and if in inequality had been perpetuated, then how to compensate? How will you compensate those classes of citizens who have been discriminated since ages? So, dear students, the basis of doctrine of compensatory discrimination is that unequals must not be treated as equals. This is the reason that other backward classes, scheduled castes, and scheduled tribes, they need reservation in public employment because they are socially and educationally backward. And this system of reservation is unique in our country. In other nations like United States, this compensatory discrimination is known as affirmative action. Why it is called affirmative action? Because government is enacting specific statutes and laws for betterment and protection of the weaker sections of the society. The constitution framers enacted this compensatory discrimination system for backward classes and tribal communities through equality clause in our Constitution of India. Compensatory discrimination is a term coined for the policy or programs that give preference to a group or group of people with a stated goal of countering and compensating the past or ongoing atrocities, excesses, injustices, or discrimination of any kind against them. This measure has been adopted for uplifting the weaker sections of a society by several countries. As I told you, that in USA, this compensatory discrimination is called as affirmative action. A direct application of compensatory discrimination can be seen in reservation of seats in educational institutions and reservation of vacancies in public services. So far as the object of compensatory discrimination is concerned, the object of CD is that a society as a whole should grow. It is necessary that every section of the society takes part in the development of the society. And at the same time, every section should also receive the benefits of the growth. A society can never grow if several sections of the society are repressed or exploited. It is also true that historically several sections of our society have been discriminated against and there exists a prejudice against them in the socially uplifted sections. So to bring such downtrodden sections of the society at the same or comparable level, the society as a whole must take special efforts and measures, which is exactly what the object of compensatory discrimination is. In a nutshell, the total object of CD is to uplift and bring the unequals on the same footing as that of upper caste in the society. Dear students, all of us know that Indian Constitution equality provision are the basis of this compensatory discrimination in the shape of reservation. We have seen that concept of equality or fundamental right of equality is provided in Article 14, and this article has two parts: equality before the law and equal protection of the laws. We have also learned earlier that equal protection of laws does not mean that every person shall be taxed equally, but that persons under the same category should be taxed by the same standard. If government is to levy income tax, then you know the current exemption limit of income tax is 2.5 lakh. So people having income up to 2.5 lakh are categorized in one group and no tax is levied on them. Then thereafter there are different slabs of income tax: 10%, 20%, 30%. So the guarantee of equal protection is given to all those groups of income tax payers because each group is not equal. There is a differentiation in circumstances. There is a difference in their income. So higher income groups are levied more income tax at the rate of 30% also. But the people having lesser income, they are taxed at the rate of 10% or 20%. And people having income below 2.5 lakh are totally exempted from payment of income tax. Similarly, the legislature may exempt certain classes of property from taxation at all, such as charities, libraries, etc. And government may impose different specific taxes upon different trades and professions. Dear students, Article 16 of our Constitution provides for equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. Clause 1 of Article 16 says that there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. Equality of opportunity will be there. Then clause 2 says that no citizen shall, on grounds only of religion, race, caste, sex, decent place of birth, residence, or any of them, be ineligible for or discriminated against in respect of any employment or office under the state. Word only is important here. That's why I have highlighted it in red color. That the ground of discrimination cannot be only religion, race, caste, sex, descent, place of birth, residence, or any of them. If there are more than one grounds, then of course discrimination can be made. Similarly, clause 3 of Article 16 provides that nothing in this article shall prevent Parliament from making any law prescribing in regard to a class or classes of employment or appointment to any office under the government or any local or other authority within a state or union territory, any requirement as to residence within that state or union territory prior to such employment or appointment. This clause authorizes the government to prescribe that reservation shall be provided only to the residents of that particular state. Suppose I belong to scheduled caste category and I am a resident of UP. Then I will get a reserved seat in the category of scheduled caste in UP only. If I will appear in Delhi Judicial Services examination, then I will be treated as a general candidate. So reservation is always provided state-wise, and in central services, reservation may be provided according to rules of the central government. So this is for the benefit of downtrodden sections of the society, that each state has its own reservation formula. Then we have clause 4 in Article 16, which says that nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any backward classes of citizens, which in the opinion of the state are not adequately represented in the services under the state. So this clause deals with the reservation for other backward classes, OBCs. Then, dear students, clause 4 capital A was added in our constitution. You see, initially the reservation is given in the first appointment, but later on government decided to give reservation in the matters of promotion also. So clause 4 capital A was added, which says that nothing in this article shall prevent the state from making provision for reservations in matters of promotion also to any class or classes of posts in the services under the state in favor of scheduled caste and scheduled tribe, which in the opinion of the state are not adequately represented in the services of the state. So by addition of this clause 4 capital A in Article 16, now government has power to give reservation not only at the initial stage of initial appointment, but reservation is to be given at the time of promotion also. This is again an example of compensatory discrimination in favor of scheduled castes and scheduled tribes. Then, dear students, another clause was added in Article 16, that is Article 16, Clause 4, capital B. By this addition, the principle of carryover rule was introduced. Suppose in 2020, 100 vacancies of civil judge junior division were advertised, and as you know, reservation policy, 27% seats were reserved for OBCs, 21 for scheduled castes, and 2% for scheduled tribes. Now let us take example of scheduled castes that out of 21 vacancies reserved for them, only 10 vacancies could be filled because only 10 suitable candidates were found eligible to the post of civil judge junior division. Now in the year 2020, 11 vacancies were left as unfilled. Now in 2021, again 100 vacancies are advertised. Again scheduled castes will get 21% reservation. But those leftover unfilled vacancies of 2020, 11 vacancies, which belong to scheduled caste category only, those vacancies will be added in the next year recruitment. They will be carried over to the next year, but they shall not be counted towards 50% reservation in 2021. Because if you will add 11 vacancies in 21 for the coming year, then obviously the reservation will go above 50%. So this article 14.4b says, 16.4b, it says that nothing in this article shall prevent the state from considering any unfilled vacancies. I'm highlighting unfilled vacancies. Unfilled vacancies of a year which are reserved for being filled up in that year in accordance with any provision for reservation made under clause 4 or clause 4a as a separate class of vacancies. See, these unfilled vacancies now shall be treated as a separate class of vacancies to be filled up in any succeeding year or years, and such class of vacancies shall not be considered together with the vacancies of the year in which they are being filled up for determining the ceiling of 50% reservation on total number of vacancies of that year. So those leftover vacancies are to be treated as a separate class of vacancies, and they are not to be added in the 50% formula of the current year. From plain reading of these articles, it is very clear, dear students, that state is empowered to legislative classification, but class legislation and another thing is also clear, that article 16.4a are not part of original article 16, but they are subsequently added by the Indian government, which wipes the gap between the general and backward classes. And further increase the reservation up to 50% in each government vacancies. You see, the initial limit of reservation as set out in M.R. Balaji's case was that reservation shall be less than 50%. Then in Indra Sahni versus Union of India, it was said that reservation shall be up to 50%. So less than 50% means out of 100, only 49 seats can be reserved. Whereas up to 50% means that out of 100, 50 seats can be reserved. So there is a difference of 49 and then later on 50. Then dear students, Article 16 provides that the reservation may be made for any backward classes of citizens. This article does not contain the word caste, but it talks about class. Does that mean that caste and class are synonymous? Probably no. A caste may constitute a class. This is how the SCs, STs, and OBCs have been treated as a class, which have further been considered as backward, and reservation is provided to them under Article 16, Clause 4. Then, dear students, we have also seen that Article 16 Clause 1 is a facet of the doctrine of equality enshrined in Article 14. Article 16 Clause 1 does permit reasonable classification, just as Article 14 does. Reasonable classification ensures the attainment of equality of opportunity assured by Article 16 Clause 1. And for assuring equality of opportunity in public employment by Article 16 Clause 1, it may well be necessary in certain situations to treat unequally situated persons unequally. If scheduled castes or scheduled tribes are unequals as compared to general category, they should be treated unequally. And not doing so would perpetuate and accentuate inequality. If you are treating all the castes and classes by the same law, that will lead to inequality. So if you look at the policy of reservation, you will conclude that Article 16 Clause 4 is an instance of such classification implicit in and permitted by Article 16 Clause 1. And Supreme Court, as you know, held in Indira Sahni versus Union of India, that indeed, even without Clause 4, it would have been permissible for the state to have evolved such a classification and made a provision for reservation of appointments or posts in their backward classes in their favor. Clause 4 nearly puts the matter beyond any doubt in specific terms. So dear students, like Article 14, classification is permitted by Article 16 also. Thus, scheduled castes and scheduled tribes, they form a class by themselves. And classification has been held to be valid by the apex court as fulfilling the test of reasonable classification. Dear students, you must read Indira Sahni versus Union of India judgment. According to ratio decidendi of this judgment, which upheld the reservation for other backward classes, that is OBCs, in the services. This case came after government issued an order in 1990 reserving 27% of posts for other backward classes. And this order was challenged before the Supreme Court. To understand fully the Article 16 Clause 4, four of the following terms which appear in the said article need to be fully understood. Number one, who is the state? In the very first lecture, we have learned who is the state as defined in Article 12. Then who are backward classes of citizens, which in the opinion of the central government are not adequately represented. So opinion of the central government is important. Then whether they are adequately represented or not, for that data is required. So looking at the spirit of Article 16, state has to first form an opinion about which caste or community could be classified as backward and whether the class so identified is adequately represented in the services under the state or not. And after completion of this exercise, nothing shall prevent the state from making reservation for other backward classes of citizens. Dear students, it should be very clear in your mind that Article 16 Clause 4 does not confer any right on scheduled castes or scheduled tribes, and there is no constitutional duty imposed on the government to make reservations for SCs and STs, either at the initial stage of recruitment or at the stage of promotion. In other words, Article 16, Clause 4 confers a discretionary power on the state to make reservations of appointments in favor of backward classes of citizens, which, in its opinion, are not adequately represented in the services of the state. Then, dear students, Article 16, Clause 5 is one more exception to the principle of Article 16, Clause 1 and 2. This clause says that a law which provides that incumbent of an office in connection with affairs of any religious or denominational institution or any member of the governing body thereof shall be of a particular religion or belonging to a particular religion. Yes, government can say that head of Ram Janambhoomi Trust in Ayodhya shall be a Hindu. And government can also say that the head of Waqf board shall be a person from Muslim community. This power has been given to the state by Article 16, Clause 5. Then, dear students, another addition in Article 16 is 16, Clause 6, which was added by 103rd Constitutional Amendment 2019, which came into force on 12th January 2019. 16.6 says that nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any economically weaker sections of citizens other than classes mentioned in Clause 4, in addition to the existing reservation and subject to a maximum of 10% of the posts in each category. This addition shows that government is empowered to grant 10% reservation to economically weaker sections of the society, but they should be other than the classes mentioned in Clause 4. That means they should be belonging to a class which is not mentioned in 16 Clause 4. 16 Clause 4 deals with reservation in favor of any backward classes of citizens, which in the opinion of state are not adequately represented in the services of the state. So apart from OBCs, scheduled castes and scheduled tribes, barring these groups, if there is any other citizen who is economically weaker, and government has defined also as to what is economically weaker section. So a person who is not belonging to these three categories is also entitled to 10% reservation if he is economically weaker. This careful reading of 16 Clause 6 shows that this 10% reservation is given to economically weaker sections of the society amongst the general category. Students may ask this question that by giving this 10% reservation to economically weaker sections of society, the reservation limit of 50% will exceed. No, it's not so. Government is not going to touch the 50% formula of reservation. This 10% reservation is given to those economically weaker sections which are part of general category. So that 50% limit still remains intact. So my dear students, this is in nutshell the doctrine of compensatory discrimination, that by providing reservation in initial appointments, by providing reservation in promotion, by permitting them to carry over the unfilled vacancies in the next year recruitment, what we are doing, we are compensating the discrimination with these categories of citizens, with these classes of citizens. That's why the name of the doctrine is doctrine of compensatory discrimination. The category or class of people who had been discriminated against since ages, now they should be compensated by giving reservations. Thank you. Thank you, dear students. Thank you very much. God bless you.